Welcome to The Explainer. Today, we're jumping right into a totally fascinating, rapidly escalating legal collision. We're looking at federal gun laws, the Second Amendment, and marijuana legalization. Let's just dive right in, because honestly, this is a perfect storm of constitutional law crashing head-on into modern societal shifts.
Let's start with a really staggering number, 20 million. According to survey data on drug use and gun ownership, an estimated 20 million Americans are unknowingly caught in a legal trap that actually makes them federal felons. That's right, 20 million people. Now, why this matters to you is pretty simple. If you, or maybe someone you know, legally purchases cannabis in your state and also owns a firearm for self-defense, well, you might be tangled up in this massive legal net without even realizing it.
And that brings us to the modern paradox we're all living in. Under state law, recreational weed is perfectly legal in 24 states right now, and medical marijuana is legal in 39. But under federal law, any use of it completely strips you of your gun rights. We're talking about a penalty of up to 15 years in prison. It's a huge disconnect.
So, to understand how we got here and where we're going, here's our roadmap. We're going to cover 1. The federal gun ban. 2. The Supreme Court's new test. 3. The government's defense. 4. The case of Patrick Daniels. 5. The historical disconnect. And 6. A national legal collision.
Okay, Section 1. The federal gun ban, understanding the trap. Let's look closely at the specific federal statute at the center of this entire controversy.
The law we're really focusing on is 18 U.S.C. Section 922 G3. This is a federal law prohibiting an unlawful user of, or someone addicted to, a controlled substance from possessing a firearm. Because marijuana remains a Schedule I controlled substance federally, which basically means the government categorizes it as having no accepted medical use and a high potential for abuse, this specific statute makes it a serious federal crime for any user to possess a gun.
And the sheer scale of this ban's impact is absolutely massive. I mean, recent Gallup polling shows that a record 70% of Americans now support marijuana legalization, 7 out of 10 people. So we essentially have a law that disarms tens of millions of citizens for engaging in a behavior that a vast majority of the country actually wants to legalize.
Moving on to Section 2. The Supreme Court's new test, changing the rules. So, how are federal judges actually evaluating this ban today? It all comes down to a monumental shift in how the highest court views the Second Amendment.
In a landmark case called New York State Rifle and Pistol Association v. Bruin, the Supreme Court completely changed the playbook. They threw out the old balancing tests judges used to use, and they established what's now called the Bruin test. This standard requires that any modern gun regulation must be consistent with the nation's historical tradition of firearm regulation.
So this breaks down into a two-step framework for judges. Step 1 asks, does the Second Amendment's plain text cover the conduct? Well, since marijuana users are still citizens, they are part of the people protected by the amendment. Then we get to Step 2, which asks, is there a historical analog? The absolute game changer here is that the government now bears the burden of proving that 922 GG3 is relevantly similar to a law that existed way back at the country's founding.
Section 3. The government's defense, intoxication, and danger. Let's take a completely impartial look at how the Department of Justice and anti-legalization groups are actually defending this ban in court.
The government, alongside several amicus briefs, presents a really robust defense based on the concept of dangerousness. They argue that marijuana is a leading risk factor for severe mental illnesses like schizophrenia and psychosis. They also state it's a common denominator in gun violence. In fact, the U.S. Solicitor General advised the courts that illegal drug users pose a greater danger than those who drink alcohol. Therefore, they argue, the ban is perfectly consistent with our nation's history of disarming dangerous individuals.
This perspective is heavily supported by prohibitionist groups. Listen to this quote from the Smart Approaches to Marijuana amicus brief. The evidence is clear. Today's highly potent marijuana causes psychosis, schizophrenia, other forms of severe mental illness, and violent behavior. So anti-marijuana organizations aggressively push this stance to the courts, arguing that modern marijuana isn't just some chill drug, but a highly potent substance that's more dangerous to society than alcohol.
Which brings us to Section 4, the case of Patrick Daniels, law meets reality. To see how these abstract constitutional arguments actually play out in real life, we have to look at this pivotal case. This specific case resulted in a ruling from the Fifth Circuit Court of Appeals that represents a massive legal blow to the federal government's stance.
It's the appellate decision that directly tested the government's historical arguments against the reality of a modern marijuana user.
Here's exactly what happened to Mr. Daniels. In April 2022, he was pulled over for a basic traffic violation. Officers smelled weed, searched the car, and found some marijuana cigarette butts and loaded guns. Later, down at the station, Daniels was Mirandized and freely admitted he smoked marijuana about 14 days out of a month. Just because of that admission of being a regular user, he was convicted under 922G3 and sentenced to nearly 4 years in prison. He immediately appealed, which set the stage for the Fifth Circuit to apply that new Bruin test to his case.
Section 5. The historical disconnect. Time traveling for analogs. This brings us to the Fifth Circuit's rebuttal, where these modern federal judges essentially had to play time machine, scouring 17th and 18th century law books for equivalents to our modern drug laws.
The court asked a very direct, crucial question. Are the government's historical laws relevantly similar to banning guns for sober, habitual marijuana users? Keep in mind, Daniels wasn't actually high during this traffic stop. The officers never noted that he appeared intoxicated. He was disarmed simply for his pattern of drug use. So did the founders categorically disarm people just for that?
Well, to answer that, the judges looked at the government's best historical examples. One was the 1655 Virginia law that banned shooting guns while actively drinking. But the Fifth Circuit countered this right away. They pointed out that historical laws only punish people for acting recklessly while actively intoxicated. Section 922G3 sweeps way more broadly than that. It categorically bans the mere possession of guns, even when a user is perfectly sober. The founders never disarmed regular drinkers when they were sober, right?
The government also argued that the historically disarmed dangerous people. And yes, the founders absolutely disarmed political traitors, British loyalists, and those deemed categorically insane. But compare that to Patrick Daniels, a nonviolent, sober citizen who uses marijuana occasionally at home. The court ruled that occasional marijuana users are not historically equivalent to political traitors or the permanently institutionalized. Because there was no true historical analog, they ruled the ban unconstitutional as applied to Daniels.
And finally, Section 6, a national legal collision waiting for the Supreme Court. So where does this leave the millions of Americans navigating this crazy legal gray area right now?
Well, honestly, it's resulted in absolute legal chaos. We are currently witnessing a massive split among federal circuit courts. The Fifth Circuit, as we just saw, ruled it unconstitutional as applied to Daniels. The Eighth Circuit rejected a facial challenge, meaning they refused to strike down the law entirely, but they are allowing as-applied challenges, meaning individuals can argue the law shouldn't apply to their specific nonviolent circumstances. Meanwhile, the Third Circuit has stated that courts must make individualized judgments. Judges across the entire country are completely divided on how to apply the Bruin test to drug users.
And this creates incredible national whiplash. For example, federal agencies like the ATF are currently warning state legal medical marijuana patients that they must forfeit their guns to avoid becoming federal felons. There's just widespread confusion. Even the Biden administration's DOJ issued internal guidance expressing concern over prosecuting nonviolent cannabis consumers who simply possess a firearm. So ultimately, to resolve this massive nationwide dispute, the Supreme Court is stepping in. They are taking up the case of U.S. versus Humani.
And that is exactly what we are going to be watching so closely. As we wait for the highest court to decide the fate of millions of gun owners, it leaves us with this final provocative thought. As legalization continues to spread like wildfire, how will the Supreme Court untangle 18th century history from 21st century reality? Can a constitutional test based strictly on the 1700s successfully navigate the complex, everyday realities of modern America? Thanks for joining me on The Explainer, and keep questioning what you know.